Well, good morning, everyone, and welcome to a new ForoCompetencia breakfast. We're starting a new year, and we have the honor to have Geoffrey Manne, who will be who is the president of the International Center for Law and Economics, and is going to talk about a very interesting topic, as which is something that I think we're seeing just the beginning of of a huge debate. So, Jeff, all yours.
Thanks, Julian. Thank you so much for having me, and I'm really delighted to be here with this esteemed group. Um, let me share my screen, or try to share my screen. We'll see how well that works. And let's see. I think I shared the wrong window. Try that again. Does that look right?
Perfect.
Okay, great. What I am going to talk about today is, as Julian says, a topic sort of near and dear to everyone's hearts, is what I call digital competition regulations, basically the DMA and its progeny happening around the world. This comes from a paper that I co-authored with my colleagues Mario Zuniga and I'm sorry, not Mario, Lazar Radish and Dirk Auer. So I want to give them credit for this. Let me dive in. I am going to cover. For some reason it's not advancing. There we go. Okay. So here's what I'm going to talk about. I'm going to talk about these digital competition regulations. Everyone knows essentially what they are, and so I won't dwell too much on the sort of the specifics of them, on the theory that you've heard it 100 times before. What I want to do is move fairly quickly to our understanding of what these things are and how they relate to traditional competition regulation. So I'm going to discuss what we call the real goals of digital competition regulation. Then I'm going to talk about the problems of digital competition regulation, and then what it portends, or whether it portends something broader in our sort of overall political economy. I should say that the paper that this was based on was written before the second Trump administration. So in some ways, the question of does it portend something beyond competition almost looks like it's been answered given the last couple of months of sort of global political economy, but we'll talk about that when we get there. So first is what these things are. Obviously, the sort of progenitor, the prototype for these is the Digital Markets Act in Europe. That was enacted in 2022, came into full force last year in 2024, and of course we've seen a number of sort of various actions under the law, with a couple of decisions coming out very soon and a couple of disputes having transpired over the course of last year and early this year. There have been similar frameworks either proposed or adopted in various other countries. Germany has an ex-ante regulation that it incorporated into its Competition Act. The UK has the DMCC, the Digital Markets Competition and something. Turkey, Brazil, India, Australia, South Korea, Japan, lots of other countries have either enacted or considered such regulations. And I want to mention in particular, I should have said this at the outset. Obviously, I'm from the United States. I'm actually from the West Coast of the United States, which is why it's dark here, because it's still very early in the morning. But I wanted to mention that that in the question and answer period, I'm more than happy to sort of field questions about things going on in the U.S. If you don't have friends or news services you trust that tell you about competition policy in the U.S. right now, since it seems to be in quite a bit of flux, I'm happy to field questions if I know the answers. But in any case, I am from the U.S. and I want to mention these U.S. bills. These are bills that have been proposed for several years now, and they sort of keep coming back. They haven't been adopted yet, but they are essentially forms of ex ante like regulation. In this case, with attributes very similar to things like the DMA and the DMCC. It's not clear whether they'll be adopted here. A couple of efforts have failed, but as I said, there does seem to be some appetite for it, and they keep coming back. I'll talk about some of the specifics of those bills as we go through this. Okay, so there are a lot of differences between these ex ante regulations, but there's some commonality as well. Obviously, they all target digital gatekeepers, usually based on a specific numerical threshold to identify the covered companies. They entail these ex ante prohibitions and obligations. They aren't effects based. They are preemptive. Um, uh, in most cases, they are separate from competition analysis and they don't employ the traditional tools of competition analysis. So there isn't a market definition exercise. As I said, it's not really an effects-based assessment. It is really a regulatory enterprise. The sort of and one of the kind of fundamental attributes is this assumption of a power imbalance. The basic justification for these rules is digital gatekeepers have an amount of power that makes essentially any dealing with them by complementers or business partners or even users imbalanced, and that this balance needs to be corrected. Um, so they're regulation, but they're not sector regulation, sectoral regulation like we're used to, but nor are they traditional competition law. Um, so a few ways in which there are sort of differences between DCRs and competition law. Um, First of all, the prototype law, the DMA, explicitly disavows competition law goals. It adopts the goals of fairness and contestability. I'm going to talk at some length about contestability because that sounds like a competition law sort of goal, but there are some important differences in the way that's implemented in DCRs. On the other hand, in Germany and Turkey, the DCR has been integrated into their competition law. Now, it's not, again, sort of, there is a difference, of course. It's part of their competition law, but it is the intent of these aspects of their now competition laws is arguably simply to make winning easier. It overrules some of the, or it they allow the avoidance of some of the procedural requirements under traditional common law in cases brought against the identified digital gatekeepers. Then we have another version of it, the DMCC, which implements a kind of bespoke requirements designed for each gatekeeper. It isn't quite the sort of single set of rules like the DMA, but its overarching goals are also somewhat different from competition law: fair dealing, transparency, open choices. Um, okay, I have a couple of slides showing these conceptual differences, and I apologize if there's some repetition, but uh, it should. It's hard to sort of cover all of the bases collectively, but here's I think the big things. No market power requirement under DCRs. Market definition is predetermined by a list of core platform services. So we've decided that search is a distinct market. You might have to prove that under traditional antitrust law. That's been predetermined under a DCR. Consumer welfare considerations are marginalized, not always completely absent, but often completely absent from DCR implementation. Efficiency defenses also often completely absent or sometimes given limited scope. And importantly, in most of these cases, in most of these laws, the burden of proof is reversed. There's a presumption of harm, and the defendants, the covered companies, have to prove that they're not violating the laws. They because the sort of because these are not effects-based laws, they don't necessarily prove, for example, there is no efficiencies defense. But in cases where the law has been sort of incorporated into competition law, we've essentially reversed the burden of proof. So, okay, traditional common law competition law principles. You could have a different list than this. There are lots of ways to construct this, but here's what I see as being the most important aspects of competition law principles. First of all, they target conduct that restricts competition. They're effects-based, right? They require an assessment of market power. They don't prohibit conduct, even if it could be restrictive of competition, unless the target has an established market power. They're based on evidence and economic effects, like I said. Typically case-by-case analysis. There are some per se rules, but for the most part, competition law is enforced on a case-by-case basis. There are procedural aspects of competition law that are informed by the error cost framework. It's very important to avoid over or under enforcing under competition law, and we think very carefully about weighing costs and benefits. And fundamentally, competition laws are rooted in the preservation of free enterprise. The Sherman Act is sometimes called the Magna Carta of free enterprise. They are meant to preserve a scope for business decisions and restrict only those that demonstrably harm consumers. Okay, under digital competition regulations, things are a little bit different. They target conduct irrespective of the effect. They predetermine which conduct will not be allowed. Instead of being based on market definition or market power, they are based on an assessment of predetermined designation criteria like number of users, size of turnover, that sort of thing. For the most part, these are per se rules with only limited exceptions rather than case-by-case rule of reason type analysis. The goals under these laws very explicitly go beyond economic concerns. They're concerned with things like power, fairness. They, in some cases, implement very specific social goals, etc. Things that are not always, but typically not in the purview of traditional competition law. And rather than preserving a sort of sphere of free enterprise, they systematically require businesses to operate in a certain manner that's sort of deemed to be preferable, generally requiring access sharing and compatibility and the like. Okay, now this ambiguous, what I'm trying to convey largely is that that these are not completely different from competition law, but they are definitely not the same as competition law. And I think one way to think about it is that they sort of opportunistically use competition law when it serves their purposes and jettison it when it doesn't. The underlying approach under these laws is a very sort of structural. They are intended to restructure markets. They take the structure of markets as sort of the most important determinant of the desirability of the way a market operates. And in that sense, they're resuscitating a kind of a largely discredited, but certainly older version of the philosophy underlying competition law. And then selectively pick bits and pieces of competition law that conform to that vision and discard others that don't, because competition law has evolved and moved largely beyond that. But at the end of the day, you could say that it's really a more stringent, more targeted, more enforcer-friendly form of competition regulation. The important difference, I think, ultimately, is these are intended specifically to structure markets or certain products or certain companies. Unlike antitrust law, which doesn't have preconceived notions generally of what a competitive market looks like. It's concerned with the effects of the way business operates in a given market. Okay, that's our rapid, for me anyway, 10-minute overview of digital competition rules. In the Q&A section, I'm happy to go into more detail. Like I said, I assume everyone is fairly familiar with them, so I'm not going into great detail. This is what I really want to talk about. Obviously, I should say it's pretty clear I'm not a big fan of these rules. So, I have a point of view in this talk. And it's totally fair that someone might think that I'm overstating the case. In a little bit, I'm intending to overstate the case to draw the distinction very clearly, and then we can talk about where around the edges, maybe I'm overstating the case, but I don't think I'm overstating it much. I think it's pretty clear, and in many cases, there are clear statements by the drafters and proponents of these laws that they're really trying to, they are aimed at three sort of effects that are, again, fairly different from traditional competition law, and that I think when viewed from this perspective, it helps us understand what they're doing and whether we should favor them or not. So those three functions are redistributing rents, facilitating rivals, and leveling down gatekeepers. Consumer welfare, the traditional lodestar of competition law, is a subsidiary consideration at best. All right, let's talk first about redistributing rents. So, as I said already, the central premise of DCRs, and again, this is very explicit in sometimes in the preambles to these laws and often in conversations and discussion documents around them. The central premise is that there are power asymmetries between platforms and other stakeholders, and that these inherently produce unfair outcomes. So right off the bat, we have this sense that the game is rigged, and we need to sort of equalize the profit-making ability of the firms participating in this exercise. It's in some cases a very explicit reallocation of profits. The goal is to, as I said, reallocate value capture across the supply chain based on certain normative judgments about what's fair. Fairness is a very explicit part of these acts. Here's a quote of how you define fairness under the DMA. Unfairness is defined as an imbalance between the rights and obligations of business owners where the gatekeeper obtains a disproportionate advantage. Now, it doesn't use the words profit, but that's the point here, right? You could replace the word advantage with disproportionate share of the profits. Importantly, because the determination of what's fair and what's not is a fairly political determination in many cases, and certainly with the DMA, there is a very political overlay here. The firms that are favored are those that are favored by the policymakers, the political decision makers. And there's a sense that the firms that are being regulated aren't just firms like any other firms. They're in a kind of political competition with the state. These are not just nice companies with whom we need to cooperate. They are rivals of the states that do not respect our economic rules, which must therefore be regulated. The power imbalance arguably extends not just to commercial rivals and complementary users, but in fact to the state itself is claimed to be somewhat disadvantaged by these companies. Let me give here an example to illustrate the rent redistribution point. Some of you may be familiar with this. Under the DMA, all of the covered companies have to provide their DMA compliance plans. Apple provided its compliance plan with respect to its 30% commission in the App Store. The claim was the 30% commission that Apple charges. There's so many exceptions to that I won't go into now, but let's just say the concern was when they do charge this 30% commission, it was deemed to be unfair. Now, again, it's not just there are other aspects of this that don't relate to the redistribution of rents. There were structural aspects of the way they operate their app store that are also deemed problematic. But here we're literally talking about the amount of money that they take. So Apple introduces its compliance plan. It reduces the commission from 30% to between 10 and 17%, imposes a small payment processing fee, very much in line with payment processing fees for credit cards and the like around the world, and adds this so-called core technology fee, a 50 € fee for each first annual install over 1 million installs. So there's a sort of safe harbor, and then they start charging this fee. That fee in particular drew the ire of the developers who distribute their apps through the App Store. In fact, one responded saying it was malicious compliance that spits in the face of open markets, fair competition, and the European Commission. But when you strip away the rhetoric, and if you look at the various blog posts and actual literal responses filed with the Commission by those who thought this fee was problematic, it's very clear that what most concerns them is that they thought Apple would be getting a smaller cut of the in-app payments and paid download fees. And at the end of the day, it looked like Apple was proposing a version it thought was compliant with the DMA requirements that might not actually reduce the amount of money, at least not appreciably, that Apple took. And that seemed to be the fundamental source of the problem. Can I ask, Julian, for some reason I can't see a clock on my screen. Where are we in terms of time and how much?
No,
I have.
go ahead. Go ahead. We're fine.
Okay. Okay. So rent redistribution is an important part of these laws. The recipients of those rents vary by jurisdiction. I won't go into this in great detail, but just understand that they vary according to the politics of the jurisdiction in which the law is being implemented. Okay. The second, and I think most interesting part of these laws is their objective in facilitating rivals and promoting this idea of contestability. Under competition law, we often talk about competition law as preserving the so-called quote unquote competitive process, and understanding that the competitive process sometimes means rivals fail, and in particular mean that that less efficient businesses, even small businesses that everyone thinks are important to promote, may have a hard time competing. And we think that's okay because ultimately it results in the preservation of the competitive process results in more value for consumers. DCRs, on the other hand, are designed specifically to facilitate competitors, even if they've fallen behind through their own inferior investment, innovation, or product offerings. The idea that animates this is this idea of contestability. The idea that making markets more contestable through regulatory intervention will ensure that they produce the desired results. It's hard to, under traditional competition law, we can just say maximize consumer welfare. Under DCRs, it's a little harder to capture what the desired result is, but whatever it is, contestability is supposed to get us there. What's most important, I think, is, and I've mentioned this before, but it bears consistent repeating, is that under DCRs, there are really no mechanisms to distinguish between anti-competitive exclusion and competition on the merits. It's just a presumption that more contestability is always preferable, regardless of why a firm might have trouble competing. Okay. This reference to the term contestability makes us think of the concept of contestability from traditional economics, pioneered by Baumol, Panzer, and Willig. And indeed, many of the defenders of DCRs suggest that contestability in particular is very consistent with traditional competition law. This is one of the reasons why these laws are not such a deviation from traditional competition. Obviously, under the DMA, we have fairness and contestability as the two primary objectives. It's very hard to say that fairness is exactly the same as competition law, although there are plenty of examples where people have said that. Andreas Munt has said that that's always been the objective of competition law in Germany. The Indian Competition Commission has said that fairness and contestability have always been the objectives of competition law. We can dispute that, but contestability really sounds like something we've always been concerned about, removal of barriers to entry under traditional competition law. Okay, so the theory of contestability is pretty easy to understand, although there's a lot of specifics that make it much more complicated. I'm distilling it down. Basically, it says that as long as entry and exit are possible, even if you have a very small number of firms present at this current snapshot of the market, the firm may still behave like it's competitive, even though there's only 2 or 3 firms or even only one firm. Importantly, under the theory of contestability, it's a dynamic process. The market, especially where there are scale economies, if the market can't withstand having additional competitors, having contestability means sometimes these competitors will enter. It also means that sometimes they will fall away from the market, and there may be fluctuations in price as this happens, generally converging, the theory says, on the competitive price. But there will be firms that go out of business, firms that enter the market, and fluctuations in price. It's very difficult to look at a particular snapshot under this theory. The policy implication under the traditional economic theory is let's remove barriers to entry, or let's ensure that there aren't artificial barriers to entry that impede this exit and entry of firms. There isn't really a basis under the economic theory of contestability for artificially expanding competition beyond the existing oligopoly, because doing so doesn't necessarily add anything. If the market is already behaving as if it's competitive, you don't need to add more firms in order to make it competitive. It's already competitive. Looking at the number of firms competing doesn't tell you exactly how competitive the market is. Okay. The DCR version of contestability is quite different, I think. It assumes that digital markets lack contestability. And there's this really interesting aspect of them that sort of says, as long as consumers consistently use the dominant platform, it must be that markets are not sufficiently contestable. Now, that's a kind of a repudiation of the idea of network effects and data advantages and even product differentiation. But it really is a sort of underlying animating principle. We know that these firms are not sufficiently contestable because we have gatekeepers that consumers consistently engage with. So we're going to engineer contestability because it's not happening naturally in these markets. So we impose things like mandatory access, sharing, compatibility. The objective is the dissipation of incumbent share, again, because the continuation of consumers using the dominant firm in droves is an evidence that there isn't sufficient contestability. So the only thing that will show us that we have sufficient contestability is successful entry by competitors. And that is essentially the goal of these digital competition acts. Again, it's a structural goal. It's aimed at making the market look different regardless of the challenger's relative efficiency or the effects of the obligations that deliver this outcome on consumers. Okay, in order to get through a little bit more of this, by the way, I'm happy to share these slides if it's of interest. And as I said, this is based on a paper which you can download anywhere. You can download from SSRN or our website. So I'm gonna rush through some of this. I apologize if you're quickly trying to read the slides and wondering why I'm not talking about parts of it. But let me say that because of the misapplication of contestability theory in DCRs, we have a couple of things result from that. There are potential costs of doing so. There are disregards of potential efficiencies, and most importantly, I think, is this a sort of lack of it's not a lack of understanding. It's a denial, I guess, of the importance of dynamic competition. um, uh, as Brian Arthur, famous economist, cautioned, in the increasing returns world, in the world of scale economies and network effects, the world of digital platforms, things are more complicated. And the the structural approach that says more firms competing leads to more competition is much harder to maintain in the increasing returns world than in the traditional world, and has costs to doing so. Okay, so this is the part I'm going to sort of speed over. The mechanisms, well, I'm not going to speed over it actually. What I may do is lop off some of the end of the talk. Okay. uh, I think this is actually really interesting. The mechanisms by which the DCRs facilitate contestability, facilitate rivals, there's essentially two primary mechanisms. The first one, as I already mentioned, is sort of forced resource sharing. So this takes the form of data portability requirements and sharing mandates. It takes the form of interoperability requirements. It takes the form of prohibitions on self-preferencing. Each of these has important costs. Now, each of them, again, arguably is a way of reducing the cost of entry or the costs of consumers switching from an incumbent to a new entrant or a rival. So it's not that these things can't have positive effects, of course. It's just that they also have negative effects that are sort of systematically disregarded. So, for example, sharing mandates make it very hard to build your business model on if you have to share your data, it undermines a database business model. It may reduce incentives for all firms to collect and organize data, and empirical research shows it has a pretty mixed effect on competition. Interoperability requirements create problems for consumers. Self-preferencing in particular is there's plenty of empirical evidence to show that consumers generally benefit from self-preferencing. There's even empirical evidence showing that competitors often benefit from platform self-preferencing. Uh, the problem with prohibitions on self-preferencing is that it tends to freeze innovation by preventing the evolution of platform functionality. That's because when the platform develops some new functionality itself, it wants to implement it. If it knows that by doing so, it has to allow other firms to compete away its advantage, it's less likely to do so. Okay, this is, I think, in a way, the more interesting way that I think DCRs facilitate rivalry, and that is through regulatory access. So systematically, these rules allow competitors and rivals to have a say in how the regulated businesses operate. Now, that's always been true in competition law as well, in the sense that in common law jurisdictions, competitors can bring a case. They often have a cause of action, and of course, they can bring complaints to enforcers. But this is a little bit more institutionalized. In some cases, you have explicit consultation with competitors to establish conduct requirements. Under some of the US bills that again haven't been adopted, they have these elaborate mechanisms that basically allow competitors to the exclusion of the companies themselves, to determine whether a firm gets to change its interface, for example. Under the DMA, you have this competitor feedback mechanism that really drives enforcement priorities. I mentioned the response to the Apple compliance proposal with respect to the to its App Store fees. That's a institutionalized part of the process. Stakeholder feedback determines whether compliance measures will be deemed accessible or not. And commission investigations are based primarily on competitor complaints. So in a sense, there's this problematic dynamic where competitors are effectively granted authority over rivals' product design choices. That is not how traditional competition law works, although again, as I said, there's some fuzziness around the edges, but I think it's actually an important aspect of this. Sorry, I moved ahead too quickly. For facilitating rivals in DCRs. The importance of rivals is elevated, and especially over the importance of consumers in these laws. The third primary function of these laws is to level down gatekeepers. Now, some of this is kind of implicit in what I've been saying already, but um, but because of this kind of rent redistribution aspect, there's an inherent sense that it's because gatekeeper success is sort of inherently problematic, regardless of how it's achieved, we're okay with taking them down a peg. Excuse me. So under there's some examples under the Turkish e-commerce law, it's actually very explicit. It requires dominant platforms to lose power. Under the DMA, a lot you could say that many of the prohibited conduct is conduct that basically prevents the dominant firms from realizing their full potential, essentially constraining them, diminishing them from what they, in some cases, are, but certainly could be in the future. Um, okay. Uh, those, I think, are the three primary things. Now, alongside these are two more points. DCRs, as I've said multiple times, in DCRs, consumers are an afterthought if they're considered at all. I won't elaborate on this more than I already have, but it's very clear, right? That the scope of allowable defenses, the standards of review, the standards by which compliance is judged, the whole philosophy underlying these laws is all about rivals and leaving aside the occasional rhetoric that mentions the word consumers, consumers really aren't present in these laws. A big switch from traditional competition law. Here are a couple of examples that I think are worth. Oh, well, lights are going off in my room. Here are a couple of examples where I think the implementation of DCRs pretty clearly have the capability, at least, of harming consumers, even though they may benefit rivals. You can read these, but the sort of important overarching point, is this underlying normative assumption that less gatekeeper power justifies consumer welfare losses. We don't need to concern ourselves with consumer welfare losses because the reduction of gatekeeper power is itself a goal that we should promote. Now, I do want to be clear that, again, in all of these cases, ultimately, I think those who promote DCRs think the benefits of reducing gatekeeper power will sort of filter down to consumers. In that sense, you could say consumers aren't irrelevant. They're just not part of the mechanisms that we look at when we're looking at these DCRs. My view is that the diminishment of the role of consumers is that even if they want these things to benefit consumers, there is no reason to think that they necessarily will, and there are rarely mechanisms within these laws if it turns out that promoting the interests of rivals doesn't promote the interests of consumers, there are few, if any, mechanisms to rejigger things so that we can actually make sure that consumers benefit. Okay. There obviously I've been suggesting there are problems with with these sort of approaches. In general, this redistributive competition regulation entails some theoretical and practical problems that I think are probably impossible to overcome, and if they're not impossible to overcome, they're very difficult to overcome under the procedures and structures of these laws. Okay, first of all, fairness is an inherent notion of these laws, and it's inherently subjective. Competition analysis historically has avoided concerns, at least explicit concerns with fairness. Big problem with fairness, with implementing fairness, especially when it's in a redistributive context, is there are no clear limiting principles or stopping points to requiring the redistribution of rents from the defendant to the complainant. Again, the Apple DMA compliance example is it shows us this. So remember, the developer reaction to the compliance by Apple was, no, still unfair, doesn't give us enough money. Okay, what would a fair fee be? who decides based on what principle? And if a 17% fee isn't sufficient, would a 15% fee be okay? Would a 12% fee, 5%? It's hard to see any logical stopping point other than either zero or when the self-interested demands of complainants sort of run out. When the cost of lobbying, of rent seeking, of seeking those rents becomes larger than the value they can obtain from. That's what a redistributive sort of system looks like, and it's extremely problematic when it's coupled with an unanswerable concept like fairness. Okay. Also, because of the sort of general avoidance of error cost limiting principles, you have a greatly exaggerated problem of lack of information on the part of regulators, this difficulty in determining what optimal prices and terms are, of course. Um, excuse me. You have the problem that these are regulating rapidly evolving technological markets. Regulation inherently usually takes longer than the regulation of the market itself. And that's particularly problematic. It's bad enough, I guess, when you have kind of evolving case-by-case enforcement under antitrust law. But if you have very strict structures put in place by ex ante, by regulation, the longer it takes to adjust those in response to changing markets, the more restrictive they'll be. And of course, that means you have mistaken prohibitions harmful to innovation ecosystems. Another problem is it's kind of implicit in this idea of fairness is sort of fairness for whom? Why is it not considered unfair to retroactively punish legitimate investment by firms? Um, uh, there is a clear kind of political preference, and that's fine. Legislation is inherently political, but there's a clear political preference for fairness for some, but not for others. And that creates, among other things, a time inconsistency problem. It makes it hard to make investment decisions if you know that subsequently you're going to potentially lose the value of those, face penalties for making lawful investments. There's also a risk that it undermines the trust and credibility in the regulatory bodies, as I said, creates a risk for future investment. All of this leads to disincentives for innovation. um, uh, I've talked about this already, but I think that look at the specific investment disincentives. It's worth sort of just highlighting these. So if you put sharing mandates on, you make it less likely that firms will engage in the collection and will invest in the collection and processing of data. Self-preferencing obligations means less investment in vertically integrating your platform to improve its quality. Um, Side-loading mandates, app store access mandates means that curation is less likely to be where you base your investment. By the way, consumers clearly value curation. There's no question that all kinds of studies show that consumers really like it when firms sort of limit the choices they have to make. Here you have a set of laws that basically say you really kind of can't do that anymore. The irony of this is that if it's true that these laws reduce innovation and investment incentives, ultimately you're going to have fewer new entrants, which is claimed to be the objective of these laws. Now, it's an empirical question whether the artificial opening of these systems, which unquestionably makes it cheaper for new entrants to enter, will be larger, or whether the constraints on investment incentives and other sort of perverse incentives to close systems will be larger. But they definitely are both consequences of these laws, and they point in exactly opposite directions. Okay, that's pretty much the same as what I've already said. Okay. I want to leave time for questions. So before I get into this this sort of final part of my talk. Maybe I'll pause for questions now, if that's all right, Julian. And happy to have a discussion around what I've already said, or I can move on if there aren't questions and talk more about where I think this fits into the larger questions around competition policy and even global political economy more broadly right now.
Okay, thanks. Does anyone has any question now? Or you prefer to continue and ask later?
Okay.
Okay. Go ahead.
It's all so clear. Okay, so what does this portend, if anything, for competition law and sort of political economy more broadly? I think three things in particular. Abandonment of the consumer welfare standard in competition law, or at least movements in that direction. Increased competition law increasingly aimed at protecting competitors, not competition, and in a broader sense, greater state intervention in market ordering. Okay, these are all pretty inherently parts of DCRs themselves. So I won't go into too much detail, but I mean, as I've said many times, DCRs very much incorporate an abandonment of consumer welfare, the notion of protection of competitors, and by their nature inherently are involve much greater state intervention in the way markets and are organized and products are designed. So the question, I guess, is how much will that influence the way competition law looks? So we have a very recent, as in 2 days ago or 3 days ago, competition law decision from the European Union that maybe gives some, well, certainly not answers, but some suggestions of the way DCRs or the DMA in Europe might be influencing the way competition law looks. So that's the Android Auto decision. Again, in the interest of time, I'm not going to go into huge detail. And I should also say, although I know a lot about European competition law, there are certainly gaps in my knowledge there. So even if I did try to go into great detail, I'd probably get something wrong. But the general overview is this. Basically, it's an essential facilities sort of case. The question at issue in the case is whether Google, with its Android Auto product offering, had to allow a particular app that may or may not have been a competitor with Google access to Android Auto. First of all, I want to say that sorry. So the fundamental issue is essential facilities, a duty to deal, and it's fundamentally a ruling on the competition law justifiability of self-preferencing. First of all, I want to make one sort of procedural point. One of the arguments in favor of these DCRs has always been that competition law is too slow and we need something that's faster and puts a thumb on the scale in favor of regulators. This law was decided in 3 years. I'm sorry, this outcome was decided in 3 years. Now, you may still think that's too slow. It's not clear that DMA processes are going to be much faster than that. It's at least an interesting indication that maybe there isn't so much difference between the two. And if that's your reason for adopting a regulatory approach over a competition law approach, it may not be such a strong one, but this also could be an aberration. Okay, but what I think has happened is we see the influence of the DMA-like approach on competition law. So here what happens under the Android Auto case is a essential dilution of the standard for mandating access, essentially an abandonment of the essential facilities doctrine. Under this decision, there's no need to show indispensability. There's no need to show the essentiality of the facility that is being accessed. You don't have to show the elimination of competition. Access is required if the facility is merely convenient to competitors, not essential to competitors. And the notion of competition is actually very broadly defined here to encompass entities that are not even necessarily really in competition with the platform itself. It also kind of shows a shift, I'm sorry, one example is probably not enough to say it's a shift, so maybe that's wrong. It is a potential shift from the notion of exceptions to rules, in the sense that um, the default expectation becomes access to platforms, rather than the default being businesses get to choose who they do business with. The default expectation is you have to do business with anyone who wants to do business with you. With some potential exceptions. It requires exceptional justifications to refuse access. You could certainly say that the notions of private property and freedom of contract that have arguably been, sort of important linchpins of competition law over the years are subordinated. And those investment concerns I mentioned under DCRs, the idea that if we sort of hand competitive advantage over to rivals, they won't invest as much in trying to compete. The idea of free riding is also largely disregarded in this decision. Okay, what's particularly important here is that it's an example of showing, I think it helps us see what DCRs portend for the regulation of ecosystems. And the bottom line here is that basically, under the Android Auto decision, and this would very much be true under DCRs, if your platform is designed for your own use, it has to be closed. If your platform is designed for third parties, it has to be completely open. There's no middle ground. There is no curation. There is no allowance for control over the specific design of the platform. It's either open or closed. And paradoxically, of course, many companies may be incentivized to adopt more closed systems in order to avoid these access obligations. Again, arguably the exact opposite of what DCRs are trying to achieve. Certainly not a traditional concern of competition law. Um, I think it's fair to say that if Android Auto portends a consistent shift under European competition law, it even potentially moves things further than the DMA approach. So under the DMA, there are some limiting principles. The gatekeeper, in order to require interoperability, it applies only when the gatekeeper interoperates with its own services. It's limited to gatekeepers with platform services. It has to be a designated gatekeeper meeting its specific thresholds. Um, it's clear that sort of the underlying impetus is one of non-discrimination, not or there are concerns around the concerns under the DMA arise when access is unequal, not just when it's denied. Under Android Auto, arguably, all of those are sort of pushed aside. Any infrastructure designed for third parties must be open to all. It doesn't matter whether it's also used by the platform itself. It presumably applies beyond the designated platforms because that's not an aspect of competition law, right? The idea of designated platforms. It encompasses this very vague potential competitive relationship standard that, again, really expands the universe of firms that deserve access beyond, I think, perhaps what even the DMA would determine, and therefore may require even more expansive access rights. Okay, here's the fundamental kind of catch-22 is this. What the Android Auto case shows us is that if what you really care about is interoperability, it turns out that's achievable without the DMA. You could do that under competition law. Arguably, that's been true in many settings in European competition law for a long time. The Google Shopping case is a good example of a step on the way toward Android Auto. But under Android Auto, you have essentially mandated interoperability, and you did it without the DMA. But I do think that you probably wouldn't have had the result in Android Auto if it hadn't been for the DMA. In other words, I do think the DMA is influencing the way competition law is interpreted in Europe. And in a way, it's almost necessary that that happen. Because the DMA and because DCRs adopt both the rhetoric and in some cases the actual objectives and processes of competition law, it would be weird to have two competing competition laws that look distinctly different from each other. Um, because they're not a complete break from competition law, it's inevitable that they will influence the way competition law looks. It's also inevitable that competition law will influence the way the DMA looks, I should say. Now, it's harder in that case because you have literal, explicit regulation, legislation passed by Parliament. But once these things get to courts, I think we can assume that courts are going to have a hard time completely abandoning the competition lens that they're used to viewing these kinds of relationships through, and that indeed competition law will influence the way DMA looks. But for now, the inverse is also obviously true. Now, this bigger, broader question is really just sort of musings on our part. It's impossible to draw a causal relationship between the advent of DMA-like laws, DCRs, and these broader trends in political economy, but there's at least a correlation that I think is somewhat interesting. First of all, I may not have mentioned this before, but I think it's fair to describe DCRs as a form of industrial policy. I mean, when you are specifically advantaging certain companies to the detriment of others, and in many cases that tends to take on a protectionist sort of cast in the international relationships, it's very clearly an iteration of industrial policy. And of course, we're seeing a great revival of industrial policy in the US and EU and China, and probably elsewhere in the world as well. The underpinnings of the DCR approach find themselves in this, as I said, it's a sort of resuscitation of older competition law traditions, but those traditions have been revived through things like the law and political economy movement in legal scholarship, the neo-Brandesian movement in antitrust policy, and post-liberal, I have a question mark next to economic because a lot of what we're seeing today in so-called post-liberal economic theory is not really very economic. But in any case, post-liberal theory has a lot of alignment with both the underpinnings of DCRs and the process by which they're implemented. Excuse me. And we are indeed seeing regulatory approaches across other domains that look an awful lot like what we're seeing with DCRs. So we have these fair share proposals for telecommunications infrastructure. There's one of those in Brazil right now. There's one in Europe. There are elements of that are already incorporated into US telecommunications law. We've seen the implementation of mandatory bargaining codes for news media, labor market interventions in platform economy that are aimed at rejiggering the labor relationship, but in a way that necessarily implicates the business model of these platforms. So is this kind of approach confined to the digital economy, or is it a harbinger of a broader transformation? The reason I put the word maybe in parentheses here is because, again, we've seen a broader transformation. I mean, just in the last few months, I think it's fair to say that the global political economy looks a lot less liberal than it did a couple of years ago, let's say 5 or 6 years ago, and certainly in the last few months. Okay, so just to recap, I think DCRs pursue fundamentally different goals than traditional competition law, although they adopt a lot of rhetoric and mechanisms of traditional competition law. They are aimed at redistributing rents, protecting competitors, and leveling down successful platforms, none of which are attributes of traditional competition law. I think they misapply economic concepts like especially contestability to justify these interventions. Again, as a political decision, that's totally fine. Political decisions, sadly, I have no sway over political decisions, but it is very much a political decision, not very much an economic one. An inherent aspect of these laws is the marginalization of consumer welfare considerations. And then there's this question about whether they signal a broader shift in political economy approaches. For the competition policy community, I'll leave you with these questions. And there are many others, I think, that are raised by these, but these are a few of the kind of important unanswered questions as a result of the implementation of these policies. In particular, I think the middle one I've already mentioned is a very important one. How will courts reconcile contradictions with traditional competition law? I think it's going to create a real brain-breaking sort of moment if we have these two very different regimes existing coincide. Courts are going to have to find ways to reconcile them, and it's not clear what that's going to look like. Excuse me. It's not clear whether these kinds of principles will remain confined to digital markets, and I think that's an interesting question for the competition community to deal with. And finally, I think the most difficult question is going to be what metrics determine the success of these interventions. We're starting to see that happen with the DMA, but it'll be a while, of course, before we can look back and say whether these sorts of laws were successful or not. And I think it behooves us to start talking now about what exactly we should be looking for to determine whether these things are successful or not, so that we can say, look, we said if X, Y, and Z happen, these will have been a success. X, Y, and Z didn't happen, maybe they're not a success. It's a lot better if you say that at the outset than if you look back with 2020 vision. So I think it's very important, maybe most important, that we as a competition community try to grapple with how we're going to judge these laws on the assumption that some of them will definitely fail. I mean, that's just inherent in the nature of ex-ante regulation. Some of them will definitely fail. We should find ways of getting rid of the ones that are failures and preserving and perhaps emulating the ones that are actually successes, but that requires establishing metrics for determining those. So thank you very much.
Great.
Now, if you have questions, I'd be happy to answer them, or happy to
Great.
hear from anyone.
Yes, we can stop sharing the screen and opening for questions. Santiago Leon, you have a question?
Yes.
Go ahead.
Yes. It's not a question, it's more a comment.
Great.
Yes, thank you very much for being here. I was thinking at the end of your presentation of the relationship between the DMA regulations and the traditional antitrust rules and competition rules. And if I was if you were like an in-house attorney and you have to advise a company relating to doing business in Europe, for example, for you it's these new rules, they hinder innovation, they hinder, but at the end they can be more predictable and the decisions are more predictable, but because of the other option is that Article 102 and abuse of dominance has some really is uncertain way of applying, and in each country is different. But at the end, I'm acting like a devil's advocate because I agree with your general opinion. But what do you say about that?
No, it's a great point. When we do talk about it in the paper, as I said, I'm trying to be a little bit contentious in this talk. Of course, there are benefits to. There are always trade-offs in everything. I question whether we really get more predictability from these laws. I mean, we get more predictability with respect to very specific compliance obligations. It's not clear that we get more business predictability, investment predictability. So I think there's some dispute over that, but there is no question that compliance can be sort of cheaper with these laws, and that's something that should be taken into account. In fact, in a traditional error cost framework, the cost of administering the system and the cost of complying with the system are very much part of the calculation. And it's always been the case that rules are more predictable than standards, and traditional competition law, at least in the US and largely in Europe and the rest of the world too, is a more of a case-by-case common law sort of approach, more of a standards-based approach. So there is that benefit to them, but with the caveat that I don't think they necessarily make the making business decisions easier. Better for the lawyers, not necessarily better for the business people.
Okay, thank you very much.
Esteban.
Thank you, Geoff, for the presentation and to motivating us to think about this relationship between rules and competition law. I have two questions. One is you compare DCRs, as you named it, with competition law and maybe a cost-benefit approach and how this influence some goals. I wonder if you think that depending on the context, cultural and economic context of a jurisdiction, this balance could be different. And if any kind of ex-ante regulation do you think could be appropriate, even specific for one of the many issues that these regulations have been taken into account.
Sure.
And the other question is if in the case law of competition law, do you think that is there any competition concern that is a legitimate competition concern to prosecute or to litigate and it has grounds, maybe in some of the closed cases? Thank you.
No, thanks. Your first point's a really interesting one. And I think the answer is clearly yes. And in fact, I mean, one of the big problems with the way these laws tend to be implemented is that they lump these very disparate industries and business models together under this digital gatekeeper moniker. And then in some cases, like the DMA, essentially regulate them the same way. That strikes me as being a particular problem of these laws. But then you have examples like the Smartphone Act in Japan, for example, which is an ex-ante regulation, but it's focused on a very specific subset of these digital markets. And now, who knows if it will remain there or not, but relative to the DMA sort of approach, it seems like that makes a lot of sense. I don't know whether they did this or not, but in theory, you find the area where you actually think there's the greatest problem. You adopt regulations that are specifically tailored to that, as you said, reflect the social and economic concerns of your jurisdiction. And for reasons that came up in the last question, because rules are often clearer than standards, that may very well be a better approach. And of course, we have sectoral regulation in lots of areas precisely for that reason, because an ex post sort of approach is not as efficient as adopting rules ex ante and enforcing them through regulatory oversight. So I certainly think it's possible that could be preferable in some jurisdiction or another. I guess what I would say, my sort of caveat to that would be, I don't think so far we've seen that degree of considered judgment and reasoning in both the enactment and the implementation of these laws. There's really been a kind of a lot of assumptions, this assumption of general power imbalance and a real rush to impose, some sort of regulation without, I think, sufficient concern for the actual ultimate effects. If they did it the way you describe, I would be much happier with it. The other thing I would say is that, oh, I've lost my train of thought. Sorry. On your second question, I've also forgotten what that was, but I think it was a question about
It was about the case law and competition issues and competition law enforcement. If you think of the many cases about digital economy,
Yeah.
is there any legitimate concern about
Yeah.
competition law infringement on
Yeah,
some of
sure.
the cases?
Sure. I guess the answer again is sort of absolutely. I think there's always, it's not always. It must be justifiable to sort of investigate, especially when you have industries that are characterized by particularly large firms and large firms that have remained large for long periods of time. Absolutely, we should investigate what the potential problems are. And if you look at things like the logic behind the US Google search case, for example, it's a perfectly logical sort of approach. Indeed, now I don't agree with the outcome of that case because I think it didn't actually prove what it needed to prove. But had they proved that Google was adopting contractual restrictions that actually caused the inability of other firms to compete, that would be a pretty clear competition violation. And now remedying it is and would always be difficult, but I don't think that would be, I don't think it was inherently problematic to investigate that. And again, if the evidence looked different than it did, I would have supported the finding there. I'm sure there are other examples as well. Obviously, there are merger examples where we can see potential problems. There are also, but looking retroactively at mergers that happened 10 years ago, and trying to construct a but-for world, I'm less happy about those, but I certainly think that mergers should be investigated in these markets. I guess here's what I would say at the end of the day, though. The real problem with even competition cases in these markets is really what the remedies look like. And because the remedy in what I think of as being the sort of most legitimate looking sort of cases will often be based on something like an essential facilities approach, a duty to deal. I think we have to be very careful about imposing duties to deal. Luckily, in the US, we have case law that makes it very difficult to do so, but you can disagree with that case law and raises the question, what the remedies would look like from a sort of moral or philosophical perspective. And I have trouble with that as a sort of liberal economic thinker. And so while I think that's always going to be a problem in these cases, I think there'll be lots of examples where, in fact, the Google search case is like this. Even if you agree with the finding of harm in that case, I think everyone should have pause over certainly many of the proposed remedies by the DOJ, but maybe the vast majority of them create real problems for the operation of competition laws that are hard to avoid. It doesn't mean that they couldn't outweigh the costs, or the benefits of doing so couldn't outweigh the cost, but I think it's always going to be difficult in these markets.
Thank you. Thank you.
Jeff, I have a question, a sensitive one, but
Okay.
you offer yourself to answer this kind of question. You mentioned a couple of things in your presentation, which in fact was great. One was that the paper was pre-second administration of Mr. Trump.
Yeah.
Second, that, well, as you just mentioned, there's one of the main difference between these regulations and competition is that you have a much broader discretionary power, which is also has an effect a much broader political influence, or is more open to political influence.
That's fair. Yeah.
Because it is based on much broader goals. Another one thing that raises attention is the fact that all these regulations have as a target companies that have a common denominator, not just in size, but also on where their headquarters are located, not far away from where you are. The question, my question is, if these regulations are applied, would that be perceived as a non-trade protectionist measure, which is subject to what the new government calls reciprocity, but since there is no reciprocity because there are no big techs on other jurisdictions, would that mean reciprocity by other means? That is a question that I would like to know your views.
Sure. I mean, I think it's a fool's errand to try to predict what the Trump administration is going to do. What I can say is that they've made it very clear that it's quite possible that these will be perceived as non-tariff trade barriers and that will be subject to reciprocity. I mean, they've very clearly said that, and I think that they'll be, that they will selectively choose to interpret them that way when it benefits whatever their, particular political objective is. From a more conceptual standpoint, I think there's, I don't want to say there's some truth to it. I'll put it this way. If these laws were affecting large domestic companies the way they affect US companies, I think it's fair to say they would look different than they do, and they might not be implemented. If Google, Facebook, and Apple were European companies, do we think that the DMA would look like it does now? I think that's a lot less likely. Now, that doesn't mean it's inherently sort of protectionist regulation, but it has that effect, and it would look very different if it didn't have this primarily, external effect, or predominantly affect companies outside of the jurisdiction themselves. And honestly, when you look at a lot of the discussions going on in other countries that are thinking of adopting these laws, sometimes they say the quiet part out loud. I mean, they almost, in some cases, they are fairly explicit about favoring domestic companies by harming the big behemoths that in most cases are US companies. So I guess my answer is there's a little bit of fairness to the idea that there's a kind of protectionist overlay to these laws. I don't think they are inherently protectionist, because they all could apply, of course, to companies that are, to domestic companies. But will the Trump administration see them as protectionist? I think there's a very good chance that they will. I should one other caveat. Obviously, these big tech companies have a very ambivalent relationship with the Trump administration. And it's very interesting to see the Trump administration going to Europe and saying, we will protect our companies, and then adopting policies at home that are aimed very much at that are based in a lot of antipathy toward these companies. So when push comes to shove, will the Trump administration really go to bat for them? I would say only if it fulfills sort of other objectives that the administration has. So we'll see them being selective about how they adopt these retaliatory tariffs, because I don't think the administration really wants to protect these companies. I think it doesn't really care about them. It's shown that in other areas, but if it serves some larger political end, I think it will adopt retaliatory measures.
Great, thanks. Well, we're running out of time. Thanks for now your concluding remarks, please.
I've concluded. I mean, I've spoken for longer than I should have. I very much appreciate being here. Thank you for the questions, and thanks for your time, everyone. I hope to see all of you at various competition events around the world soon.
Great. Well, thanks a lot for this great presentation and for your time. And for everyone, we'll see you next month in the next ForoCompetencia breakfast. A pleasure.
Thanks, everyone. Thanks for being on.
Bye. Thank you.
Bye.
Thank you. Bye.